at University of Delhi. Welcome, ma'am, in this refresher course. Please, ma'am. Please, आप cameras on कर लीजिए अपना.
Good afternoon, everyone. Thank you, Dr. Pushpanjali, for this kind introduction. It's a pleasure to be interacting with my colleagues from different disciplines. Usually, we talk to law teachers, but this time I've been told that it's a mixed group of teachers across disciplines. So I'm glad to be talking to you all on a topic which is very, very close to my heart, and that is relating to protecting working women against sexual harassment at workplace. So we will be talking about what amounts to sexual harassment and what is the law against it, and beyond the law or besides the law, what is it that we need to do in order to make workplaces safer for women. So I'll be sharing a PPT that I have prepared. So I hope this is visible.
Yes, yes, visible.
Okay. So we'll be talking about the Sexual Harassment of Women at Workplace Prevention, Prohibition and Repressal Act of 2013. One minute. I think this is a wrong PPT that I've got. I'll change this one. I'll have to change this PPT. There's another one that I've prepared for this. So now this is the correct one. So before talking about the law, we need to understand what amounts to sexual harassment. For understanding sexual harassment, there are a couple of concepts that we need to be familiar with, and the first one is understanding the concept of sexuality. So sexuality, when we talk about it, this is not only about the physical act of sex. Sexuality is a very broad concept which talks about our emotional, our psychological understanding of the concept, our orientation. See, man is a sexual being. So for understanding the offense of sexual harassment, we have to necessarily understand this concept of sexuality, because it is only when a woman is being targeted on account of her gender, and the harassment is something to do with the sexuality of either the offender or the victim, it is only then that we call it a offense of sexual harassment. So there are two related concepts that we also need to talk about, and that is the concept of personal boundary and comfort zone. See, we all have different comfort zones with different people. There is a different personal boundary that I maintain with different people. And this is all very, very subjective. There cannot be any objective yardstick for determining. Let's see, whenever I talk to any person, there has to be necessarily a 3-foot distance or a 6-foot distance that I maintain when I talk with different people. With my family, with my friends, with my relatives, the personal boundary could be shorter. And as compared, and when it comes to my colleagues, when it comes to my relatives, the personal boundary that I maintain with them, it could be much broader. So there is a different personal boundary that I maintain with different people, and there is a different comfort zone. See, there are people, whenever I meet them, I want to hug them. Then there are people, whenever I meet them, I shake hands with them. There are some people at whom I wave from a distance, and then there are some people, whenever I come across them, I try to avoid meeting them at any cost. That is because they make me feel uncomfortable. There is every possibility that maybe there is no history of any what we call as an unfortunate incident between us, but still there are some people who don't make me feel comfortable. And that is why if they come close to me or if they violate the personal boundary that I have set for myself, I feel uncomfortable in the presence of those people. So whenever sexual behavior of whatever degree, the behavior has to be necessarily sexual in nature, and of whatever degree, it could be anything explicit, it could be something implied, it could be very subtle, it could be something gross, but it could be anything. But sexual behavior of whatever degree, when it is unwelcome, when it is imposed, and when it is not reciprocated, then that amounts to sexual harassment. See, without sounding moralistic, we have to be mindful of the fact that this is the 21st century and people have the right to choose their partners, the right to choose their friends, and consenting adults have a right to decide on what sexual behavior is good for them or what is acceptable to them. See, who are we to decide that a female is supposed to have male friends or not? If a woman is talking to men on phone, if she has got many male friends, we cannot be judgmental about this fact. It is totally her call. And the kind of conversations she engages in with other men, that is also absolutely her call, provided she is an adult, provided she knows what she is getting into. So, sexual behavior of whatever degree, it becomes problematic only when it is unwelcome. If it is welcome, if it is mutual, if it is reciprocal, then there is nothing wrong with it. The problem arises only when, despite an indication of disinterest from the side of the woman, if the man persists in that kind of a behavior, which is unwelcome, as sexual harassment. And I again repeat here that sexual harassment is a subjective experience. Just because a woman accepts compliments from one particular man doesn't mean that she will accept compliments from you also. See, it all depends. If you are friendly with someone, you can take liberties with that person, only the person who is okay with your taking liberties with them. If a person is not friendly with you, you just can't take the plea that, see, this woman is friendly with everyone, so what if I also cracked some jokes at her? There should be no problem. You cannot say that, see, I've been working for 20 years and there are so many women also working in my organization. I always compliment women when they look pretty. Or I usually comment on the color of their clothes, or whenever any woman, any of my colleagues gets a new haircut, I feel that she's looking good and I always compliment her. There is every possibility that a woman might not take objection to it, but then there is a possibility that some woman might be offended by that. So irrespective of what your intention was, if your compliment is not well received, if it has offended the sensitivity or the sensibility of the woman, it would amount to sexual harassment. That is why it is very important to draw degrees in your relationship with different people. That is, what is the personal boundary that a person shares with you, or what is the comfort zone that the other person shares with you, and then you have to be mindful of that boundary and zone in all your interactions with that particular person. So this term sexual harassment, it was coined in 1970s by Catherine McKinnon. Catherine McKinnon is a celebrated American feminist activist lawyer. Now, she was doing her PhD on the topic of sexual harassment, and she gave the definition that sexual harassment is a form of sexual discrimination and it is a gendered expression of power. See, when we say gendered expression of power, sexual harassment usually takes place in a power matrix. When you try to exploit the person who is in a lower position as compared to you. So that is your gendered expression of power. See, more often than not, men folk, even if the woman is their contemporary, even if the woman is their superior, or men born and brought up in a patriarchal society, it is very difficult for them to accept women as their equals. So, irrespective of the fact that a woman might be holding any position or any chair, for a man who has been brought up in a very entitled way, for that man, the woman is, at the end of the day, a woman only. So, for him, irrespective of the position she holds, he will always consider her to be a lesser human being as compared to him. And that is where we bring in this expression, a gendered expression of power. And when he feels that just because she is a woman, so he can take certain liberties with her without her consent, that amounts to sexual harassment. So sexual harassment, it has been defined to be of two types. One is quid pro quo and the other is hostile work environment. Quid pro quo, this is a Latin maxim which means this for that. When a woman is promised some sort of promotions or some extra increments or some preferential posting, but she is promised all this in return for sexual favors. Or alternatively, if a woman is threatened that, see, in case you don't oblige us with sexual favors, then you might be demoted, your increments might be stopped, or you might be given some extra work, and that too at a time when everyone else is leaving the office, you might be asked to stay back. That might be done to you routinely. That is again something when either you are promised something in return for sexual favors, or if you are threatened with something if you don't return the sexual favors, or if you don't oblige the person with sexual favors, then this is a quid pro quo situation. The other kind of sexual harassment is hostile work environment. So this is when sexual harassment is persistent at workplace. Like if you can see, you can see it here in the figure, like men folk, they are sitting together in a group, they might be cracking jokes. There is a possibility that they might be cracking some non-veg jokes, all at the expense of the woman who's sitting next to them. And sometimes it is possible that they are just busy amongst themselves, but they are unmindful of the fact that there is a woman sitting nearby and she might be feeling uncomfortable with the kind of jokes that they crack or the innuendos that they use. They might be unsettling for any woman. Similarly, if at the workplace you see the moment a woman walks in, there are people who have given her some nicknames, or there are people who just point out, pass some remarks on the color of the dress or the kind of her hairdo or anything like that. Or the moment she comes in, people will start finding excuses to move around the station, or people might position their chairs in a way so as to keep looking at her. On all these things, they might make the woman feel uncomfortable. See, even otherwise, trying to talk to her on one pretext or the other, unusually holding her hand for longer periods of time. That is an unusually prolonged handshake. Or positioning your chair immediately adjacent to the woman in a way so that you are touching her, you are making her uncomfortable. So all this and more, it amounts to a hostile work environment when the woman is continuously conscious of the fact that she is being observed, people are looking at her, and she'll be constantly conscious about her dress and the way she is sitting and all these things, so due to which she'll not be able to focus on her work and she'll feel uncomfortable. So all this is known as hostile work environment. So the definition that was given by Catherine McKinnon, that it is sexual discrimination, it's a gendered expression of power and it takes place in these two types. So all this was for the first time applied by the American courts in the case of Alexander versus Yale. Now Yale, as you all must be knowing, it's a very prestigious Ivy League university in United States of America. Now what happened that a few girls, they complained to the authorities in Yale University that there was a hockey coach and there was a flute teacher who were harassing the girls. So Yale said that we don't have any mechanism to address your complaints. So these girls, they were compelled to move the courts. In front of the courts, these girls, they lost the case. They lost the case by, because see, sexual harassment is a private kind of an offense in which the witnesses, it is seldom you find witnesses because it takes place in private settings, and you don't even have evidences. Law talks about evidences and witnesses. So under the ordinary legal framework, it is very difficult to prove the offense of sexual harassment and to get punishment for the accused persons. So although in this case, the girls lost the case, The positive outcome was that they were directed, Yale University was directed by the courts to set up an institutional mechanism wherein they could disregard the technical rules of procedure and law, and they could conduct inquiry, some domestic inquiry, in-house inquiry, disregarding those technical rules, in which they would base the decision on preponderance of probabilities. That is, talking to both the sides, whichever side appeared to give the more probable version, supported by other circumstantial evidences and all, so they should listen to them. See, we are talking about the late 1970s. At that time, we did not even have these CCTV monitoring mechanisms. There was people did not have these mobile phones and all, due to which it was very difficult to record evidences. Nowadays, if somebody sends across an objectionable message to a woman, she can always take the screenshot, she can save the message, and she can show it around to other people. She can have, even if something objectionable is happening, she can immediately record the incident, due to which at least she has some sorts of evidences. Then with the awareness being generated about these laws, there are other people also who are willing to come forward and testify in the woman's favor. So now we have witnesses, we have evidences, but in those days we hardly had any evidences or witnesses in such cases. People would usually not meddle into anyone else's affairs when it comes to all these things, and people would always maintain a distance from such cases. So at that time, although the girls lost the case, but the important outcome was that such a committee was instituted in Yale. Soon other universities followed suit. Then we had such committees coming up in all the organizations, in the government sector, and slowly in the unorganized sector and all. The USA enacted a law, then there were these international conventions and all which talked about protecting women against sexual harassment. And then slowly all the other countries, they also followed suit. Now, sexual harassment, we call it an invisible offense. Now, why do we say that sexual harassment is an invisible offense? As you can see on the screen, I had a good friend ask me this the other week. I am not doubting that everyday sexual harassment of women happens. I promise I know it happens. I know it is a problem. I just never really see it. Why is that, and where is it happening? Now, that's a great question. See, we say that sexual harassment is an invisible offense because the society does not take cognizance of sexual harassment till the time it does not erupt into something more violent, such as rape. And that is the time when we sit up and take notice, and we realize that maybe we should have acted faster. We should have acted at an earlier stage so that we could have prevented such a gross crime, such a what we call as such a heinous crime from having taken place. See, the problem of sexual harassment, it has got more to do with our attitudes. The attitude that we all have is that chalta hai attitude, in which we have normalized flirtatious behavior of men. We have these kind of stereotypes that men will be men and boys will be boys. And so what if a man has said such a thing? It's okay. A woman who takes offense is scared of being labeled as oversensitive. We as a society, we are very quick to judge our women. See what happens whenever any woman complains that she has been harassed sexually. Instead of looking at the conduct of the accused person, we start finding faults with the woman. That why did this happen with you? There are so many other women also working alongside you, and why did this happen only with you? Okay, maybe it has got something to do with the way you dress, the way you make your hair. Oh my God, you apply so much of makeup. You've got so many male friends. You're constantly talking to men folk on the phone. So you were like asking for trouble. See what happens that when we judge our women, they are scared to complain. They are scared to speak out. Then we start imposing restrictions on our girls. See, if a girl comes from school and tells that she was being harassed on the way, first of all, we'll confiscate her mobile. Then we'll have restrictions put on the way she dresses. then from the next day her movement would be restricted severely. Either her brother will be accompanying her to the school, college or tuitions, or it will be her father's duty. In worst cases, she might be asked to stop her education and sit at home. See, in our country, what we find easier is to impose restrictions on girls instead of tackling the situation. And that is why we have these restrictions, such as we say that girls should not move out at night. Girls should not go out during the late hours. Why? What is the problem? Because it is not safe for girls to move out at night. Who makes it unsafe for women to go out at night? Men folk. So ideally, who should be restricted from moving out at night? Men. But who do we restrict? Women. And that is because it is easier to put restrictions on women. Now this has to change. Now all this is because of our socialization. What do our movies, these series, these daily soaps, what do they show? Boy follows a girl, the girl says no, the boy refuses to take no for an answer. He keeps pestering her and eventually she says yes. That is what the movies have shown. Hasina maan jayegi. And we have stereotypes such as inkar ikrar ki pehli sindi hai. Now what happens due to this socialization? Boys, they refuse to understand that once the girl has said no, if you are still following her, this amounts to the offense of stalking. But that is not something that has been taught to them by the movies. पिक्चरों में ऐसा तो नहीं दिखाया ना. पिक्चर में तो यही दिखाया, लड़की ने मना किया, लड़का फिर भी पीछे गया, and eventually the girl is impressed and she says yes. Okay. Now the movies that have been seen by boys, the girls have also been fed on the same dose of movies. So what they feel, even if the girl wants to say yes, she believes that if she says yes, she'll be taken as an easy person. So she feels that she has to act pricey. Now what happens? She sends out mixed signals. She is saying no, but in her heart she wants to say a yes. So that is what leads to stereotypes such as the kind we hear when we say that when a girl says no, she means yes. If she says, when a girl says no, she means maybe. If she says maybe, she means yes. And if she says yes, she is not a lady anymore. What kind of a stereotype is that? Especially in the 21st century, do we have room for all these kinds of notions? We need to discard all these notions. We need to understand that it is the 21st century. Girls now have a choice. They have a voice. And if she wants to say yes, she will say yes. And this is important to understand, not only for our boys, but also for our girls, so that they understand and they express themselves clearly, so that we can be very, very sure when we say no, it means an absolute no. No does not mean a feeble yes. No does not mean that the woman wants the boy to coerce her to convert her no into a yes. No means no. That is an absolute, total statement in itself. There is no other qualification attached to this term, no. So this is, the offense is invisible because we as a society, we refuse to look at it that way. Then since we are judging our women, since we are imposing restrictions on women, there are several demotivating factors which compel women to tolerate all this in silence. And the silence of the victim emboldens the perpetrator in their continuance of the abuse. So it is a very, very vicious cycle which needs to be broken. And we need to talk about it and we need to address this issue. See, there are many people who say that, sexual harassment has started happening nowadays. Earlier, we did not have the offense of sexual harassment. But since now women have got educated, they are working outside alongside men folks, so these things, they are bound to happen. But sexual harassment has always been there in our society. Even if we talk about Mahabharata, even during those days, women were not free from sexual harassment. We can talk about the incident when Draupadi was working as a serendari in the palace of Queen Sudeshana, and she had a brother who was handling all the army and the affairs of state. Even the king was scared of him. That is why he could take the liberty to harass Draupadi, who was working as a flower girl in his sister's palace. So what was that if that was not sexual harassment at the workplace? Now coming to how the laws have developed in our country. Earlier, before we got the POSH Act in 2013, see now we have a separate civil law which deals with the offense of sexual harassment, and that is referred to as the POSH Act, and we got this law in 2013. Before that also we had laws to deal with sexual harassment, and that was in two sections of our Indian Penal Code, which is section 354 and section 509. 354 deals with molestation and 509 deals with eve-teasing. Now, what is the difference between eve-teasing and molestation? When you comment on a girl's appearance, or when you sing songs directed at her, when you flash a body part at her, or when you make any objectionable gestures at her, but all this is done from a distance, that amounts to eve-teasing, which is punishable under 509. But if in doing so you touch the girl, grope her, push her, or in any way use any kind of a criminal force against her while doing any of those things, that amounts to molestation, which is covered under section 354. So we already have these provisions. Then in 1997, there was a non-governmental organization by the name of Vishaka, which had filed a writ petition before the Supreme Court of India, because there was a woman named as Bhavari Devi who was working as a grassroots worker in Rajasthan state, and who was subjected to sexual harassment and a brutal rape by 5 upper caste men of her village. So when this woman was declared to be a liar by the trial court, and all the 5 accused were acquitted on the basis of very frivolous grounds by the court, such as rapes are committed by youngsters, the accused are 5 middle-aged respectable men. Other argument was that rapes are committed on young and beautiful women. Bhavari is a middle-aged, plain-looking woman. Then there were arguments such as that Bhavari is a low-caste woman, and the accused were high-caste men. So why would high-caste men rape any lower-caste woman? And then there was the argument that, see, the Indian moral fabric, especially in villages, has not deteriorated to an extent that 5 men would commit a rape in each other's presence in a village in broad daylight. And out of those 5 men, there was one Chacha and Bhatija. So they said uncle and nephew would not be committing these kind of offenses in each other's presence. Saying so, the 5 accused men who were accused of committing gang rape on Bhavari were released by the trial court. Media picked it up. There was a lot of uproar, due to which a non-governmental organization with the name of Vishaka filed a writ petition before the Supreme Court of India, requesting the court to fulfill its constitutional obligation under Articles 14, 15, 19 and 21. The Article 14 of Constitution talks about equality to men and women. Article 15 Clause 3 talks about special provisions for women. Article 19 talks about freedom of movement. Freedom of movement, which also involves freedom to work at a place of your choice. And right to life under Article 21, which includes right to live and work with dignity. So in case a woman is subjected to sexual harassment at her workplace, or when she is not safe to work at a place of her choice, so it means that we are violating our constitutional duties under Article 14, 15, 19 and 21. In addition to that, India is bound by its international obligations under CEDAW. CEDAW, which is Convention on Elimination of Discrimination Against Women. Then India is also a signatory to the Vienna Accord of 1994 and Beijing Women's Conference of 1995, under which we've all proclaimed it aloud at international forums that we are committed to ensuring safety of our women within their homes as well as outside in the workspaces. So if women are not safe, see, Bhavari was a grassroots worker. She had offended the higher caste men of her village by objecting to them marrying off their 9-month-old daughter. Rajasthan is notorious for child marriages. So when Bhavari had objected, that was the reason that they all thought that they would teach her a lesson, and in order to punish her, a group of 5 men from that family, they had committed rape on Bhavari Devi. But they all were acquitted by the trial court, due to which Vishaka, the non-governmental organization, it filed a writ petition and in the Supreme Court, and the Supreme Court has powers under Article 141 of the Constitution to issue certain guidelines till the time law is not enacted by the legislature. See, in our country, we have separation of powers. So, lawmaking is a legislative function. But we all know that making of a new law takes years. So sometimes when it is very, very necessary to enact a law urgently, so what happens, till the time law is not enacted, the judiciary steps in and formulates certain guidelines, and those guidelines, they serve as law till the time the legislature does not enact a law. Once the law is enacted duly by the legislature, then those guidelines, they cease to be operational and the law takes its place. That is why we got these Vishaka guidelines in 1997, and they continued to protect our working women against sexual harassment till 2013. In 2013, we got the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013, which is the civil law known as POSH. And also we got a criminal remedy against sexual harassment in the form of Section 354A in the Indian Penal Code. This also happened in 2013. This was in the wake of the Nirbhaya incident that took place in December 2012. The legislature stepped in, and the criminal laws, especially related to safety of women, they were amended big time. So at that time, sexual harassment was acknowledged as a specific crime under the Indian Penal Code, providing the penalty of imprisonment and fine to the accused person. And we also got this POSH Act, which is the civil law, Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, which provides a civil remedy in the sense that the accused, he can be demoted, his increments can be stopped. In extreme cases, he can be removed from his service also. And additionally, he might be asked to provide some compensation to the woman whom he is accused of having assaulted or subjected to sexual harassment. So this is a civil remedy. Now these two remedies, they work concurrently. Like, it is not that if a woman has sought some protection under this POSH Act, so she cannot file criminal charges against the man, she is free to do so. It is totally her call. If she wants, she can initiate civil proceedings to get that man punished at the workplace and to take civil action against him. And additionally, she can also initiate criminal charges against the accused and get him imprisoned under the law. So she has both these remedies that work side by side. Now, legally, what amounts to sexual harassment? So for this, we have two definitions. We have Section 2N of this POSH Act, which is the civil law, and we have Section 354A, Clause 1 of the IPC, which is the criminal law. The definition is almost the same, and it incorporates the same things that we had earlier discussed when we were talking about Catherine McKinnon's definition, that she said sexual harassment is a form of sexual discrimination, a gendered expression of power, and it takes place in two forms, which would be quid pro quo and hostile work environment. So the definition is more or less the same. Still, we'll discuss that. And in a lighter vein, so this, you can see this cartoon, a female employee going to the boss, and she is saying, I want to complain about sexual harassment. But the boss is on a different trip. इसमें भी वही वाली पिक्चरें देखी हैं ना हमारे बॉलीवुड वाली, because the boss comments, you know you are beautiful when you are angry. इसने वही फिल्में देखी हैं कि कोई हसीना जब रूठ जाती है तो और भी हसीन हो जाती है, या फिर कैसे कैसे हमारे गाने होते हैं, गुस्सा इतना हसीन है तो प्यार कैसा होगा. So this boss, when he makes this kind of a comment, little does he realize that he has given rise to a fresh case of sexual harassment, and now if the woman employee wants, she can also accuse him of sexual harassment. So now coming to the definition of sexual harassment, there are two definitions. One is the criminal law definition, one is the civil law definition. Under the criminal law, which is Section 354A of the Indian Penal Code, it says a man committing any of the following acts. So when we say a man committing any of the following acts, it is like this one is a partially gender neutral provision, in the sense that the one who can be accused of committing sexual harassment can only be a man. But the victim can be both a man as well as a woman. So for the first time, our criminal laws have acknowledged that a man can be a victim of sexual harassment. A man can be sexually harassed, but that can be done only by another man. See, this law is not totally gender neutral, in the sense that a woman cannot be accused of sexually harassing another man. It is only a man who can be accused of sexually harassing either a man or a woman. A woman cannot be accused. She can only be the victim here. So what does the law say? A man committing any of the following acts: physical contact and advances involving unwelcome and explicit sexual overtures, or a demand or request for sexual favors, or showing pornography against the will of a woman, or making sexually colored remarks shall be guilty of the offense of sexual harassment. And then we have this other definition, which is given under the POSH Act or the Sexual Harassment Act. Under Section 2N, first, the implementation aspect. Now, since the title of the law says sexual harassment of women at workplace, Prevention, Prohibition and Redressal Act. So the title itself makes it very clear that who is protected under this law? Only women. So under the civil law, it is only the woman who can be the victim. But the perpetrator can be both a man as well as a woman. So a woman can accuse another man of sexual harassment. She can also accuse another woman of sexually harassing her. See, what does the law say? Sexual harassment includes any one or more of the following unwelcome acts or behavior, whether directly or by implication, namely physical contact and advances, or a demand or request for sexual favor, or any other unwelcome physical, verbal or non-verbal conduct of sexual nature. So here what is important? Here the conduct should be of sexual nature and it should be unwelcome. And who can be the accused? It could be a man, it could be a woman, but who can be the victim? Only a woman. So this is the difference between implementation of the civil law and the criminal law. Under the criminal law, the offender can only be a man, victim can be both a man as well as the woman. Under the civil law, the offender can be a man as well as the woman, but the victim can only be a woman. Now, in addition to that, what may amount to sexual harassment? So, under Section 3(2) of the POSH Act, the law says, the following circumstances, among other circumstances, if it occurs or is present in relation to or connected with any act or behavior of sexual harassment, may amount to sexual harassment. 1. Implied or explicit promise of preferential treatment in her employment. 2. Implied or explicit threat of detrimental treatment in her employment. 3rd. Implied or explicit threat about her present or future employment status. 4. Interference with her work or creating an intimidating or offensive or hostile work environment for her. And 5th is any humiliating treatment that is likely to affect her health or safety. So this is same as we had discussed earlier when we were talking about quid pro quo. When you are either promising her preferential treatment or you are threatening her with detrimental treatment in her employment, or if it is a threat about her present or future employment status. Now, this could be expressed, this could be implied, but at any rate, if a woman, she is either being promised something or if she is being threatened with something, all this is in exchange for sexual favors, then this may also amount to sexual harassment. So as you can see from this chart, what may amount to sexual harassment? If you take her pictures without her consent. Sometimes what happens, a man may position his chair in front of the woman and then he'll pretend as if he is scrolling some messages over his phone, while actually he might be clicking her pictures or making videos. So if you have the consent of the woman to do that, there is no problem. The problem is when you are doing it without her consent. So capturing images, stalking her, whether you are physically stalking her or whether you are monitoring her activities online. Sometimes what happens, the woman, she is doing her work peacefully. The moment she goes on WhatsApp, there is someone who's waiting for her to come online. The moment she goes online, whether it is on WhatsApp, whether it is on Messenger or any other social media platform, immediately the person starts bombarding her with messages. Why are you late today? You're looking very pretty in this dress today, or anything whatsoever. It could be anything that he is messaging the woman with. Now, again, if the woman is expecting messages from that person, it is perfectly fine. But if the woman was not expecting any messages from him, it would amount to cyber stalking or online monitoring of her activities. So that would again be the crime of stalking. Then if there is any person who's threatening her about her employment, subjecting her to humiliating treatment, making unwelcome physical contact and advances, demanding or requesting her for sexual favors, subjecting her to bullying, subjecting her to prejudicial treatment at the workplace, or creating a hostile work environment for her, adopting a discriminatory attitude towards women. See, sometimes what happens, there are many people working in an office, some men, some women, you are all contemporaries, you are all equally qualified. When there is an important function, suppose there is a dignitary coming to your institution. See, what will happen if there is an important presentation to be made? It will be a male colleague who will be doing that. And when it comes to handing over a bouquet to the guest, it would be usually a woman. So this kind of a discrimination, if it is being done only because of the gender, then that becomes problematic. Then that is wrong. Similarly, making sexually colored remarks or showing pornography to a woman against her will, all this and more, it amounts to sexual harassment. So why do we have this law? To provide protection to women against sexual harassment at workplace. To prevent sexual harassment from happening, for that we need to have gender sensitization programs so that people know what is acceptable and what is unacceptable conduct. Then in case there is any such event that happens, we need to have a mechanism for redressal of complaints of sexual harassment, and we also need to look into related or incidental matters. See what happens, the woman might have complained that this man is harassing me, but then till the time the inquiry continues, she has to work with him. So that could be very, very uncomfortable. So what the law provides is that if the woman wants, she can restrain that person from supervising her work. She can go on leave, she can ask that man to be transferred elsewhere, or she can ask for any temporary relief till the time the committee does not come to its conclusion. And the committee also has to work in a time-bound manner, like the maximum time that is provided there to dispose of the complaint is 3 months. So during those 3 months, if the woman wants, she can go on leave, or she can get herself transferred or the accused transferred. Now coming to the definitions under this law, this is a very, very progressive law, and that is why the definition that we see under this law, if we talk about the definition of aggrieved woman, it says, aggrieved woman includes a woman of any age, whether employed or not, who alleges to have been sexually harassed by the respondent, and in relation to dwelling place or house, a woman of any age who is employed therein. See, when we talk about sexual harassment at workplace, we usually presume that there has to be an employer-employee relationship. But this is a very, very progressive law which applies to every woman, whether she is working at a particular place or whether she has just visited that place in relation to any work. See, for example, there is a woman who has gone to the bank to deposit her check. She is not working there, but she has gone there in relation to her work, and if some bank employee harasses her there, she can file a complaint with that bank, with the internal committee of that bank, and in case there is any outsider visiting that bank who harasses her there, she can ask the bank officials to provide her with the CCTV coverage, or if there are any witnesses around, she can ask them to testify in her favor, and they will all help her because they are legally obliged to do so, to help her to register an FIR. So any place that a woman visits in relation to work, that would be considered as the workplace. An aggrieved woman is a woman, whether she is employed or whether she is not employed at that place. Then it also talks about women of any age. See, sometimes, although we might like to believe otherwise, because in our law we know that child labor is prohibited, but there are so many cases wherein people, they will leave their young daughters to work at an employer's house. They'll say, okay, you don't give her money, she'll work only in exchange for food. So if she is harassed, she is a minor, she might be a 5-year-old girl, she might be a 6-year-old girl who's working at that place. Even if she is not being paid, she is not working for remuneration, but still if she is being harassed, this is a law which protects her. So this is a law which applies to both the organized as well as the unorganized sector. It has a very broad definition also when it comes to unorganized sector. It says any place where 10 or more people are working will be deemed to be an organized sector workplace. See, 10 or more than 10 people. So now you have to have necessarily an internal committee, even if there is not a single woman at your workplace, because there is a possibility that some woman might visit your workplace in relation to her work. So even if there is no woman employed in your workplace, but if there are 10 or more than 10 people working together, it amounts to organized sector. And wherever, even if it is an organized sector and there are less than 10 people working, then they may not form an internal committee. Then their cases, if they have any such cases, then it goes to the local committee. So in the organized sector, we have internal committees, which is mandatory for every establishment to have. And otherwise, for those women who are working in the unorganized sector, there is a local committee which is constituted by the district officer. District officer is the district collector or the district magistrate, whosoever is notified by the state government in this behalf. And he constitutes a local committee at the district level to look into all complaints of sexual harassment taking place in the unorganized sector in that district. So this is a law which protects women who are working, whether for remuneration or otherwise, whether they are employed full-time, part-time, temporary, permanent, employed through agency, through a contractor, whether they are paid in cash or kind. It could be anyone. But it doesn't include any family member of employer. That is because family members, if a woman of the family wants to complain, she can complain under the Domestic Violence Act. This is only for women who share this employer-employee relationship with you, irrespective of whether they are being paid or not. Then coming to the definition of the term employer. It has also been defined very broadly. An employer is any person who is responsible for the management, supervision and control of the workplace, and management includes the person on board or committee responsible for formulation and administration of policies for such organization. So you can't take the plea that, see, our employer sits in Chandigarh, or we work for the central government and our employer sits in Delhi. Wherever you are working, in your unit, who is the person who is responsible for the management of affairs of your organization, of your setup in that particular unit? That person will be deemed to be the employer, and it will be the responsibility of that employer to conduct sensitization programs, to constitute an ICC, and to ensure that all women at that workplace are safe. Then definition, unorganized sector, any enterprise where number of workers is less than 10. This is for the purposes of this law. Then coming to the definition of workplace, because the law says sexual harassment at workplace. So workplace also has a very broad definition. Any place which the employee visits arising out of or during the course of employment, including transportation provided by employer for undertaking such journey, as well as a dwelling place or house. So the definition provided by statute itself is broad and does not restrict the place of work of the perpetrator to physical environment of workplace. It takes into account all possible access places, point scenarios wherein the aggrieved woman can come in his contact. And the workplace term, it needs to be notionally extended to include team outings, cab services, online meetings. As did witness during the last 3 years during the pandemic, we were working from home. So although if I was attending an online meeting, like this kind of function, if it is going on, I'm sitting at my place, but if somebody says something to me that offends my sensibility, so although I am sitting at my place, but still that would be considered as a workplace because I am in an official meeting or an official workshop. Similarly, if the employer sends you somewhere for some meeting, similarly, if you have an official group, wherein everybody is sharing messages or anything that is official in nature. See, all you colleagues of a college or of an institution, in case you make a WhatsApp group which is not official, if somebody shares any defamatory or any such note in that group which is not official, that would not be considered to be workplace. That is, it is your call. You can take a criminal action against such an act, but it would not be covered under the definition of workplace. Here, workplace has to be something which is necessarily official in nature. Any place where you are because your work requires you to be there, not an unofficial thing. Then what are the duties of employer? So again, before proceeding, who is an employer? Employer is the one who is responsible for the management of that particular unit. जहाँ भी 10 या 10 से ज़्यादा लोग काम कर रहे हैं, तो वहाँ पर whosoever is responsible for the management will be deemed to be the employer. So it is the duty of the employer to provide safe work environment at the workplace. Safe work environment means it should be properly lit. There should be no, as we say, as those dark spots or dark places, dark alleys. There should be a proper CCTV coverage. If possible, there should be more than one woman working during any shifts. If a woman is working during a night shift, so it is the responsibility of the employer to provide her a safe pick-up and drop facility. If there are any parking spots and all, they should all be properly lit. So we have to try and minimize chances of any such sexual abuse. In addition to that, it is the duty of the employer to display at a conspicuous place the policy of organization against sexual harassment, the consequences of sexual harassment, and the order constituting the internal complaints committee. So first of all, the employer has to constitute an ICC. Then he has to put the order constituting the ICC, consisting of the names of the ICC members, their phone numbers, their email IDs. All this has to be displayed on the notice board. And also he has to put it on the notice board or display it on the website of the organization, that the organization has adopted a zero tolerance policy against sexual harassment. And if anybody indulges in any such act, then these would be the consequences of the harassment. Then, in addition to that, it is the duty of employer to organize sensitization workshops for the employees, organize orientation programs for the members of ICC. See, like in today's program, there are all these it's an interdisciplinary program, so we have teachers from management and other disciplines. So more often than not, there is a possibility that you are not aware of what the law is. You might not be knowing that the members of ICC have all the powers that a civil court has. You can summon witnesses, you can call for evidences. You have you are duty bound to follow the principles of natural justice. The judgment, like judgments are given, similarly, the report of inquiry has to be submitted in a very, very detailed format, the way judgments are written by the courts of law. So ICC members, they need to be oriented and told that how are they supposed to conduct the inquiries once any such matter comes before them for inquiry. So it is the duty of the employer. It is not that he constitutes a committee and then he can just lie back and relax. It is his duty to ensure that the ICC is working properly. For this, the employer should provide necessary facilities to the committee for dealing with complaints, conducting inquiry, including securing presence of witnesses and respondent. Wherever required, if the aggrieved woman wants to file a criminal complaint, it is the duty of the employer to help her. In addition to that, once the committee has been given a case, he has to report timely submission of reports. See, this is a very, very confidential work, so the employer cannot meddle in the affairs of the ICC. The employer cannot ask for details of the case or ask to be briefed about what is happening in the case, but he can just monitor that, because this is to be done in a time-bound manner. Within 3 months' time, 90 days, the committee has to give its report. So the employer is bound to monitor the timely submission of reports by the committee. Then he has to treat sexual harassment as a misconduct under service rules and initiate action against the misconduct. And he also needs to submit annual report of the cases filed, if any, and their disposal to the district officer. So who all are protected? This we've already done. Then, what is the redressal mechanism that is provided under the Act? Under the organized sector, there is an internal committee that is to be constituted. Earlier, we used to call it the Internal Complaints Committee. At many places, people still call it the ICC or the Internal Complaints Committee and the LCC or the Local Complaints Committee. But there was an amendment in 2016, and now the term complaints, it has been removed, because it is believed that the jurisdiction of committee is much broader than just looking at complaints. They also have to organize these orientation programs and sensitization workshops, and they also have to submit the annual reports and all. So they have a broad-based job that they have to do. So that is why the term complaints has been removed, and now it is an internal committee and local committee. So under Section 4 of the Act, there's constitution of internal committee has been provided, under which there has to be one chairperson who has to be necessarily a woman, minimum of 2 members from within the organization. Out of those 2 members, one has to be necessarily a woman. And there should be one external member. External member in order to ensure privacy and in order to ensure what we call as impartiality. So that the working of the committee is not biased. That is why they have to necessarily hire an external member who could be either a lawyer or someone who is well versed with law relating to women, and someone who might be working with some non-governmental organization or any organization that is committed to the cause of women's safety and welfare. So this should be the constitution of the ICC. Similarly, the local complaints committee is constituted by the district officer in every district. They engage people who are working within that district in the government or in the private sector, but people who are working within that district, they are called to be members of that committee, and the officer of Women and Child Development Ministry posted in that district is the ex officio member of this committee. Whenever there is an incident of sexual harassment, the complaint has to be made in writing within 3 months from the date of incident. So that is the time. If there is a delay beyond 3 months, then it is for the committee to see whether there are any justifiable reasons for the delay, in which case they may condone the delay or they may refuse to entertain the complaint if it is submitted after 3 months from the date of incident. Sometimes sexual harassment is a continuing offense. So in such cases, 3 months is to be counted from the date of last incident. Option of conciliation is available to the woman alone. No one can compel her to go for a conciliation. It is only when the victim wants that she can ask the committee that, see, I would like to explore the option of conciliation. The option has to come from her side. She cannot be compelled by either the accused or the committee members to go for conciliation. And the option of conciliation is to be provided at a very, very initial stage. If the conciliation fails or if the woman does not want to go in for conciliation, it is only then that the inquiry begins. And once the inquiry begins, then there cannot be any conciliation. Conciliation is to be opted at the very, very initial stage. And another safeguard in place is that monetary compensation cannot be a basis for conciliation. See, this was important to check the misuse of this law. Otherwise, women would be filing fake complaints, take money, and then take back their complaints. They would be targeting men with deep pockets. So in order to curb this kind of an abuse of the law, this option of conciliation has been provided at the initial stages, and that too there is an express bar on monetary considerations being a basis for conciliation. So money cannot be given. Even if the woman wants to take back her complaint after the man apologizes, it is perfectly fine, but no money is to be given to her for that. But if after the conclusion of the inquiry, if the committee feels that the woman has suffered some physical, mental agony for which she needs to be compensated, so at the time of completion of inquiry, if they want, they can give her some compensation, and that compensation is to be recovered from the accused's salary. Where his salary can't be deducted, then it serves as a charge on the property. His property can be even sold off to recover the money, and it can be given as compensation to the woman. Then, during the pendency of the inquiry, within 3 months, if the woman does not want to continue working, she has the option to be transferred or to go on leave. In this, जितनी भी उसकी छुट्टियां बची हुई होंगी, चाहे CL है या EL है, जो paid leave है, so she needs to exhaust that, and after that also she can be on leave, but that will be an unpaid leave. But the thing is, she cannot be removed from services even if she is an ad hoc or a contractual, temporary or a daily wage employee. During those 3 months, she cannot be removed. Then coming to reliefs, if the charges of sexual harassment are proven against the accused, the committee may either ask him to tender a written apology, they can let him off with a warning, they can leave him after a reprimand or censure, they can withhold his promotion, his pay raise or increments can be stopped. In extreme cases, he might be terminated from service. In addition to that, they may ask him to undergo counseling session or perform community service. Wherever required, action may be taken for sexual harassment as a misconduct in accordance with service rules. And if required, the committee can also recommend payment of compensation to the aggrieved foreman. Another very important thing about this law is that sometimes we've seen that the law is misused. Women file fake complaints, or they try to produce false evidences and doctored witnesses. So if it can be proven by the accused person that her witnesses, her evidences were fake, then action can be taken against the complainant woman for filing a false complaint. But here we have to be mindful of the fact that because sexual harassment is a private offense, so more often than not, we don't have evidences and witnesses in this case. Just because a woman is not able to prove her charges does not mean that her complaint was fake or malicious. In case she is to be prosecuted for malicious complaint, then the burden lies on the accused person to adduce evidences or to produce witnesses which can testify that yes, the complaint made by the woman was malicious or false. In addition to that, all the proceedings, they are to be done in a very secret manner. Wherever not required, the name of the accused, witness or the complainant, nothing is to be disclosed. It is only when the committee adjudges the accused as guilty that his name can be disclosed. But even at that time, the identity, name or address of aggrieved woman or the witness or respondent should not be disclosed. If anybody discloses, the member of committee or anyone else, then they can be punished. And there is a penalty of disclosure, which is ₹5,000. See, after this, if the complainant feels that the punishment was less that was given to the accused, or if the accused feels that he has been wrongly implicated, or if no action is taken, so whosoever is aggrieved by the recommendations of the committee, they can file an appeal as per their service rules, whatever your service rules say. If your appellate authority is the labor court or the industrial tribunal, accordingly you can file an appeal before the court. Once the committee has submitted the report, the employer cannot sit on the report. He has to necessarily take action within 60 days. In addition to that, the government has to monitor the implementation of the law, maintain data and inspect records, call for information, make rules. And it is the duty of the government to take measures to publicize the app. See, like the workshop that we are having today, you are not from a legal background. Still, there is this workshop on POSH for you. Why is it required? So that each and everybody knows that yes, there is such a law in place and this is what the law says. In case the employer does not comply with the law, that is, does not constitute the internal committee or does not take action on report of committee, does not submit annual reports or contravenes any other rule or penalty, then even the employer can be punished with a fine of ₹50,000 in the first instance. There could be double the punishment in case of repeat of non-compliance, and there could be a cancellation, withdrawal, or non-approval of license or registration for carrying on business, trade, or activity. Now, this is a famous case of KPS Gill and Rupam Bajaj. You must have heard about it. KPS Gill was a super cop to whom goes the credit for tackling insurgency when terrorism was at its peak in Punjab. Now, this man, he was accused of sexual harassment by a senior IAS officer, Mrs. Rupam Bajaj, who said that during a party in an inebriated stage, KPS Gill, he positioned his chair in front of her in a very, very uncomfortable way for this woman. When she got up to move away from that place, he slapped her on her bottom. So she alleged that she was sexually harassed by him. But this is an old case. We did not have the POSH Act or a provision under criminal law to deal with sexual harassment, but we had the provisions of molestation and eve-teasing under 509 and 354. So she charged him. Since he was a very senior police officer, so this, although she was a senior IAS officer, but she faced a great deal of difficulty in getting the police to register an FIR or conduct investigations against him. And eventually the fight went on for more than 10 years, and finally the Supreme Court convicted him and held him guilty of outraging the modesty of a woman. So this was a case which sent out a loud and clear signal that no matter how high and mighty you might be, no one is above the law, and the law will eventually catch up with you. So he was convicted, but he was released on probation of good conduct. But this was a very, very publicized case. Then coming to Me Too case, coming to this Me Too movement, which is a social media movement. Now, this is not something which is legal, strictly legal, because it does not have any legal connotations, but this was a social media movement because women who were disillusioned with the due process, who thought that the courts were taking too much of time and the Police and courts were viewing their complaints with skepticism. So these women, they came together on the social media to empathize with victims, to tell them that, see, you are not alone in this. This has happened to me too. So to demolish the culture of silence, they would name and shame the offender on social media. So even if the law did not catch up with the accused, at least his name and his reputation in the society could be shattered. So this was, women were empathizing with each other that, see, it has happened to me too. So you are not alone in this. But what happened, it was seen that the moment a man's name had been recommended for some higher position, or when his promotion was due, immediately there would be some allegation of Me Too against him in the media. And sometimes the cases would be 20 years old, 30 years old. Nothing wrong with narrating what had happened, but the timing of that allegation, when a woman chose to go public with her allegations, when they timed with the elevation of a particular man, so all this raised questions regarding the obliqueness of motives of the movement, due to which this movement, it did not grow as much as it could have grown, because people started looking at it with some sort of a skepticism that maybe it is not entirely true. So before we conclude, we always talk about the duties of employers and all. It is important to know the duties of employees also. We should know the policy. We need to educate ourselves and our fellow employees. Wherever we see any inappropriate behavior, we should recognize that, raise our voice against that, and immediately report that to the authorities. All the employees have a duty to maintain the sanctity of the workplace by maintaining professionalism in behavior, attitude, and dressing at workplace. See, many times we see women saying, proclaiming loud, my life, my choice, perfectly fine. This choice, it applies to dressing also. But every place has its own rules and regulations in place. So if there is a prescribed dress code, if there is any decorum that needs to be maintained, it is our responsibility to abide by the same. So there are different clothes that are to be worn at official meetings, unofficial meetings, at the beach, at an evening party, at a wedding. So there is a different unsaid and unofficial dress code for that. Whatever you choose to do, whatever you choose to wear, be careful, be mindful of the place that you are visiting. This is not only for women, this is for men too. Then all the employees, we need to conduct ourselves in a manner that will minimize and diffuse any potentially harmful situation. We should have the courage to say no, to nip the evil in the bud. And if there are any other employees facing harassment, we need to cooperate with them, we need to support them, and also to cooperate with the committee during inquiry proceedings. If we know anything, we need to open up to the committee and share it with them. Why should we adopt zero tolerance against sexual harassment? Because remember, it can happen to anyone. And if it happens to you, remember, it is not your fault. It can happen to anyone. So it's better to talk to someone you can trust. You need to document incidents, write down when, at what date, what happened, and also to confide in people. This is because tomorrow those people, they can come and serve as your witnesses. They can testify in your favor. If you see any incident of sexual harassment happening, whether that is happening against you, against anyone else, object, raise your voice. Trust and support people who confide in you regarding the harassment that they have faced. Counsel them about their rights, support them, and make the harasser stop. Otherwise, the harasser will continue their behavior with one or the other victim, and if left unchecked, the behavior may escalate to graver forms. To conclude, as Malala said, we cannot succeed. Here we means no society, no people, as it is the human race. How can we succeed? How can we be happy when half of us, that is women, when half of us, when 50% of the population, women folk, they face multiple demotivating factors, even if they want to study, even if they want to work. So when half of us are held back, how can any society, any nation, any people be happy? How can they be successful? That will be all from my side. Thank you. And now the floor is open for questions.
Ma'am, I have two questions. फर्स्ट ऑफ ऑल थैंक यू सो मच फॉर दिस वंडरफुल प्रेजेंटेशन। जैसे कि आपने कहा कि इट कैन हैपन टू एनीवन, तो हमें लीगल एस्पेक्ट्स जानना बहुत ज़रूरी है। मैम मेरे 2 क्वेश्चन हैं। फर्स्ट क्वेश्चन के 2 पार्ट्स हैं। फर्स्ट, अगर हमारा कोई कोलीग है, लेट्स से वो मेल कोलीग है, और वो हमको कोई ऑब्जेक्शनेबल मैसेज भेजता है, मैसेज या पिक्चर या वीडियो वटएवर व्हाट्सएप पे या किसी भी, एक तो वो वर्क आवर्स ड्यूरिंग वर्किंग आवर्स भेजता है, और दूसरा बिफोर और आफ्टर वर्किंग आवर्स। तो इन 2 केस में ये जो पोस्ट एक्ट है इस तरीके से कैसे अप्लाई होगा? और सेकंड क्वेश्चन इज, अगर हम इसमें मेल कलीग को हटा के एक फीमेल कलीग को ऐड कर देते तो उस केस में ये चीज कैसे अप्लाई?
पहला केस, अगर तो आपके वर्क आवर्स में, जैसे कि हम बात कर रहे हैं कि सेक्सुअल हैरेसमेंट, पहली चीज तो मेल कैन बी ऑल्सो गिल्टी और फीमेल कैन ऑल्सो बी गिल्टी ऑफ सेक्सुअल हैरेसमेंट। तो चाहे मेल कॉलीग है या फीमेल कॉलीग है, सिचुएशन सेम होगा, ठीक है। अगर तो वो आपको आपके वर्क आवर्स के दौरान, और आपका चाहे ऑफिशियल ग्रुप है या अनऑफिशियल, उस पर भी अगर वो आपको मैसेज करता है ड्यूरिंग वर्क आवर्स, दैट अमाउंट्स टू सेक्सुअल हैरेसमेंट एट वर्क प्लेस। After your work hours, if they are sending any objectionable message, if that is being circulated on any official group, that is sexual harassment at workplace. अगर आपका अपना कोई पर्सनल चैट है या आप दोनों सपोज कॉफी पीने गए हैं, वहां उसने कोई गलत हरकत कर दी, that is not workplace, that is sexual harassment, but that is not sexual harassment at workplace. So irrespective of the fact that you two are working together in a same organization, you don't have a civil remedy against him, but yes, you have a criminal remedy against him. It amounts to sexual harassment, for which you can register an FIR under section 354A of the IPC.
Thank you.
मैम, आपने
सीमा, आपकी आवाज कट रही है।
मैम, जो आपने लीव का प्रोविजन बताया था, एक्सक्यूज मी मैम, एम आई ऑडिबल? जो लीव्स का प्रोविजन है मैम, कि या तो जैसे मेल अगर है तो उसको ट्रांसफर करवा सकते हैं, हम डिमांड कर सकते हैं, या फिर छुट्टियों पे भेज सकते हैं, तो फीमेल के लिए भी सेम प्रोविजन जो आपने बताया था, तो वो क्या था मैम?
मेल का ट्रांसफर करा सकते हैं। यू कैन आस्क कि कमेटी रिकमेंड कर दे, उसका ट्रांसफर कर दे या आपका ट्रांसफर कर दे। छुट्टी पे आप नहीं भिजवा सकती हैं आदमी को, छुट्टी पे आप खुद जा सकती हैं। आप कह सकती हैं कि 3 महीने जब तक कि आउटकम नहीं आता इंक्वायरी का, तब तक मैं काम नहीं करना चाहती इस ऑर्गेनाइजेशन में, या तो मुझे ट्रांसफर करो या मुझे छुट्टी पे भेज दो। उसमें आप छुट्टी पे जा सकती हैं, और छुट्टी पे आप जा सकती हैं 3 महीने के लिए। जितनी आपकी पेड छुट्टियां बची हैं, पहले तो वो एग्जॉस्ट होंगी, उसके बाद आप अनपेड लीव पे रहेंगे।
थैंक यू।
Do we have any other questions?
Hello, I'm audible?
हाँ कुलदीप जी, आप ऑडिबल हैं, पूछिए।
Ma'am, I have one question. It is seen that particularly in the academic institution, whenever there is some strict principal, I mean to say gents principal, comes to the college, and he tried to put everything, all the system on place. So at that time, there are lots of harassment case. I mean to say women harassment case filed on him. So sometimes some female are also using this as a fake kind of allegation. And due to that, I still remember, when I recently joined in a college, I think I'm talking about 16, 17 years back, there was one allegation which was put in by one female lady on a principal. And, principal got a shock, and, after 2-3 months, he got a heart attack and he died. And after, after 10, 12 years, we came to know that that was a, kind of a trap, because that principal was very strict. So, ma'am, what we can do with such kind of a thing, because that lady was completely out of, all the thing, because the person is died. So who will going to put a, complaint against those wrong, activities?
See, I'll tell you, this is a very, very difficult situation, because see, whosoever is in the authority, चाहे मेल प्रिंसिपल है या फीमेल प्रिंसिपल, काम कराना पड़ेगा, काम कराने के लिए एम्प्लॉइज को डांटना पड़ेगा। प्रॉब्लमैटिक वहां है सिचुएशन जहां की जो फीमेल्स हैं, जो फीमेल एम्प्लॉइज हैं, दे ट्राई टू मिसयूज द लॉ फॉर देयर एडवांटेज, तो वो सिचुएशन का फायदा उठाती हैं। मैं आपको एक सिंपल एग्जांपल देती हूँ. सपोज देयर इज समवन हु कम्स लेट टू द कॉलेज एवरी डे. अब लेट आने वाले को तो आप डांटेंगे, कहेंगे ना कि डेकोरम मेंटेन कीजिए, टाइम पे आइए, ठीक है. तो एक तो डांटने का ये तरीका है कि अगर आप अगली बार लेट आएंगे तो आपको मेमो सर्व किया जाएगा या आपके खिलाफ एक्शन लिया जाएगा. लेकिन कई बार क्या होता है, लोग बह जाते हैं. वो क्या करेंगे, इन औरतों को तो नौकरी पे रखना ही नहीं चाहिए, इन औरतों का तो सिंगार ही पूरा नहीं होता, क्या ये तो पहले अपने पति और बच्चों का टिफिन पैक करेंगी, ये तो हमेशा अपने काम को सेकेंडरी मानती हैं. तो ऐसी जब आप टिप्पणियां किसी औरत पे कर रहे हैं बाय वर्च्यू ऑफ हर जेंडर, so this is sexual harassment. You understand? So you have to be mindful of who you are talking to when you are in the authority. Second thing, simple काम कराने के लिए डांटना पड़ेगा, काम भी कराना पड़ेगा, वो sexual harassment नहीं है. देखिए, सिर्फ because a woman goes and she complains कि मेरे खिलाफ sexual harassment हुआ है, अपने आप में वो साबित नहीं होता. उसको साबित करना पड़ेगा कमेटी के सामने, उसके लिए उसे अपने सबूत और गवाह पेश करने पड़ेंगे. और ऐसे में जो एक्यूज्ड है, अगर उसके पास कोई सबूत और गवाह है जिससे कि वो पेश कर सके कि ये शिकायत झूठी है, डॉक्टर है, तो जैसे मैंने आपको बताया सेक्शन 13-14 जो ये एक्ट का है, उसमें एक्शन कैन बी टेकन अगेंस्ट द वुमन आल्सो हु फाइल्ड अ फॉल्स कंप्लेंट और अ मैलिशियस कंप्लेंट. दिस इज हाउ इट वर्क्स.
थैंक यू मैम.
So that's it. Can we call it a day now? Or do we have any more questions?
No, ma'am.
No ma'am, not from
ma'am.
me.
Thank you so much, ma'am, for this wonderful presentation. We learned a lot.
Basically, ma'am, basically this topic is very vast. There are so many, cases, which is very situational. We never know which one is correct or which one is right. So after hearing so many incidents, sometimes we feel, okay, she is correct. Sometimes we feel that guy is correct. And ultimately, when you continue listening this kind of a thing, because there are, lots of argument from both the sides. So what you have touched upon, that is, a very important thing. When I joined, education institute, particularly in the edit section, so first lesson which I got is, भाई women development केस से दूर रहना, मतलब women harassment केस से दूर रहना भाई. बाकी तुम्हारा कुछ नहीं हो सकता, खाली ये चक्कर में फंस गए ना तो जिंदगी खराब है. तो वी आर वेरी वेरी व्हाट वी से कि ना सावधान हो जाते हैं मैडम हम लोग की ना, टू टॉक टू अ फीमेल. वी टॉक वेरी सोफिस्टिकेटेड so that there should not be any kind of allegation on this.
उन्हें सावधानी बरतने में ही समझदारी है.
मैम वही करते आ रहे हैं.
देन सॉरी,
वही करते आ रहे हैं.
मैम कुलदीप, कुछ लोग इतने बहादुर होते हैं कि वो जरूरी नहीं समझते. मैं एक इंसिडेंट बताती हूँ. जी, एग्जाम में हमारे कोई सुपरिटेंडेंट आए थे और उनको शुरू फर्स्ट दिन आते हैं, हमको पता नहीं था, तो मैंने और कुछ और प्रोफेसर ने उनको नमस्ते नहीं किया उस दिन. हम जल्दी निकल गए. बाद में मुझे पता चला कि उस प्रोफेसर ने क्लास में जाके और मेरे बारे में कुछ मतलब जेंडर बेस्ड ऑब्जेक्शनेबल बातें स्टूडेंट्स के सामने कही हैं. तो हालांकि उसकी कंप्लेन हुई, प्रिंसिपल ने आगे यूनिवर्सिटी में भी कंप्लेन करी. तो कुछ ऐसे लोग भी होते हैं जो इतने बहादुर होते हैं.
तो आपके पास तो इतने सारे गवाह थे, सारे स्टूडेंट्स के सामने बात कही गई थी, वो तो प्रोफेसर साहब अच्छी तरह से फंस जाते, तो आपने एक्शन ही नहीं लिया उनके खिलाफ. So is that it?
Ma'am, thank you so very much.
Okay, so have a nice day everyone. Bye bye.
Thank you, ma'am.
Thank you, ma'am.
Thank you, ma'am.
Thank you.
Thank you, ma'am. मैम ये सेशन की अटेंडेंस और फीडबैक लिंक नहीं आई है पुष्पांजलि मैम.
जी मैम.
ओके, थैंक यू सो मच.